Most people think revocable trusts are just for the rich, or they're very complicated, or worse, they don't even think they need one at all. My name is JP Rankin, and I'm an estate planning attorney licensed in South Carolina, North Carolina, and California. I've helped hundreds of families avoid probate, create an estate plan, and a legacy that they know will work when they need it to. In this video, I'll break down what a revocable trust is, how it works, how it can save your family time, money, and stress, even if you don't have millions. So, what is a revocable living trust? Let's break it down in plain English. Definition: a revocable living trust is a legal document that holds ownership of your assets while you're alive and distributes them after you die, without going through probate. It's a private process. Unfortunately, probate is a public process, and so it is the contract that allows you to avoid that public disclosure of all of your things, what you have, and who you want to get it. Some people don't like that, and if you're one of those people, a revocable living trust is definitely for you. Some of the key features of a revocable living trust is you can change it while you're alive. It is a living trust. It's revocable. It's living because it's created during your lifetime, and it's a trust. It's an agreement between the grantor, who is you, and the trustees and the beneficiaries. Now, sometimes the grantor and the initial trustees are the same persons. You have successor trustees that'll serve after you pass away, and the beneficiaries. So it's an agreement between all of those persons. Why use one? What are the benefits, right? Here's where a trust really earns its value. Number one, you avoid probate in North Carolina and in South Carolina. Probate in both of those states can take anywhere from 16 to 24 months. That's if nobody actually fights or contests what the will says. The trust assets avoid this altercation entirely. There's no judge oversight, there's no court, there's no filing, there's no probate fees, there's no public notice, there's no public disclosure of what's in your estate, so you can maintain privacy. Wills are public, trusts are private. Number two, the revocable living trust protects incapacity. If you become disabled or mentally incompetent, your trustee, the successor in this case, takes over automatically. No guardianship court, no frozen assets, and it works even if you're in a coma. You've already told that successor trustee what you want to happen, and you don't need an additional document like a healthcare power of attorney or a durable power of attorney that cover you if you don't have a trust. Those documents are really important if you don't have a trust, but if you do have a revocable living trust, the successor trustee automatically takes over, and there's not an additional document that a doctor or a bank needs to interpret to allow that person to act on your behalf when you're incapacitated. Number three, the revocable living trust can allow you to control the timeline of distribution of wealth after you pass away. So you can stagger distributions to your loved ones at ages and stages is something that we call it. So, maybe a third of it at 25, a third at 30, and a third at 35 if you want. You can delay an inheritance or protect a beneficiary that maybe has some problems with money. Now, I know all of our children are perfect. They never make any mistakes, but I'm sure that if you have multiple, you know that there is one who might spend more than they need to, especially if they get a large sum of money. So you control the how, not just the who. We do things other than just ages and stages. We can get as creative as you want. I had a client that said, I want to make sure that my daughter works for a reputable corporation that's going to value her and her worth and pay her accordingly. So the trustee was only allowed to distribute what she was earning in her annual salary from the trust. So every year she got a distribution that was equal to her annual salary. That's what the client wanted. And because it's a contract between the grantor, the trustee, and the beneficiary, and everyone was in agreement, that was totally doable, and it motivated the daughter to actually work harder. Another thing that a revocable living trust does that's really helpful and important is if you've got a child that you're worried they may fall into the hands of a drug addiction or may just spend more money on things that you don't want them to spend the money on and potentially drugs, you can give the money to this separate trust for their benefit and control the distribution of it, and give the successor trustee the ability to make them perform a drug test and prove that they aren't under the influence of drugs. Even if they suspect that the child might be under the influence of drugs, they can withhold the distributions until that child proves that they are no longer under the influence of drugs. And to be honest, that's one of my favorite things that a trust can provide for a parent, is because the last thing you want is a parent dying and giving a large sum of money to a child that's going to take that and hurt themselves because they are suffering from an addiction children. It's one of the coolest things that I think a trust can do to give some parents peace of mind and be able to sleep easy at night, knowing that when they die, their child is going to be protected from themselves. I mean, that's all we can really do for our children. As you can see, revocable living trusts allow you to create bumper rails for your kids while you're alive and protect them from themselves and things that they didn't even know that they were going to get into, but you've lived life and they haven't, so give them that benefit, and the revocable living trust allows you to do that. Revocable living trusts allow you to own multiple homes in multiple states and avoid probate in each of those states. So a revocable living trust can own a home in any other state, no matter where the situs of that trust is. So a South Carolina trust can own a home in North Carolina, Florida. All of those houses get deeded over to the trust, and they all are owned by one revocable living trust. So you can place out-of-state real estate into trust to avoid multiple probates, because unfortunately, if you do not have a trust and you simply have a will, that will is going to get probated in each of those states that you own property in. What a revocable trust does not do, let's be clear, they're not magic shields. No matter what you might have heard from the latest TikToker or YouTuber, they are not asset protection vehicles. Creditors can still reach the assets while you're alive, and the trust then becomes irrevocable at death. And while protections do kick in then, they are not ironclad, and they do not protect your loved ones from everything. For your protection, you'd need an irrevocable trust while you're alive, or an LLC or some sort of business entity structure to protect your assets while you're alive. It also doesn't avoid estate tax by itself. What that means is everything that you own in your estate, if it is not owned in the trust or if it does not have a beneficiary designation, it's going through probate. And the trust doesn't hide those assets. It just makes sure that they're owned by something other than you when you pass away, so they're not a part of your estate and they pass outside of probate and they become non-probate assets. Trusts can be structured with credit, shelter, or bypass trust to reduce exposure. Those things happen after the death of the first decedent. So those sort of credit bypass trusts are possible while you're alive, but only when they come from a joint trust scenario. Unfortunately, single individuals do not necessarily get the ability to benefit from a credit shelter bypass trust because they are not married and they don't get the ability to transfer things at the death of the first decedent, unfortunately, but that's the way that goes. The trust doesn't help without actually funding it. I have clients come in all the time. They say, oh, great, mom and dad passed away. That's really unfortunate, but no worries, they had a trust. And then they give it to me and I look at it and I say, yes, they did get a trust, and yes, they did try and help you out, but unfortunately, they didn't take the time to fund it themselves, or they didn't work with an attorney that funded it for them. And we do that here. We make sure that all of your assets are funded to the trust, because unfortunately, if it's not funded and then you pass away, all you spent that couple $1,000s on was a very expensive paperweight. What we like to say is an empty trust is a useless trust. You have to retitle assets, bank accounts, houses and how they're owned, brokerage accounts, business shares. You don't always have to retitle every single asset, but you do need to make sure that if it is a non-probate asset like a bank account or a retirement account, it needs to have a beneficiary designation or you've retitled it. It's an either or. Now, the house needs to be retitled. It has to be. There is no other way for that property to transfer outside of probate unless you retitle it to be owned by the trust. A pour-over will, very, very important, and we do that in conjunction with your trust. It helps you catch anything that wasn't funded to the trust, change the beneficiary designation, and a lot of times the way we see this is an old 401k from an old employer that you didn't even know existed. You pass away, and now your personal representative has to deal with $30,000 that's in your estate because it's in your name and it didn't have a beneficiary designation. That's why it's important to draft a pour-over will to work in conjunction with that revocable living trust. It'll catch that asset, it'll pour it over into the trust. So how do you use a revocable living trust? And how do you use it in real life? How do you make one? And listen, I know some of you are going to be watching this and trying to figure out how to do it on your own. Let me give you some steps to make sure that at least if you're trying it on your own, you know what to do and you're working in the right direction. So the first thing is you got to create the trust. I would recommend doing it with a qualified estate planning attorney such as myself, but you can get DIY trusts made on the internet. There are sites that'll do it for a couple $100. If you find one of those and you create the trust, great. Next, you're gonna have to name trustees. So who takes over if you die or become incapacitated? These people, and I can't stress this enough, You have to trust them. It's in the name of the role. So don't name your neighbor because they're the most convenient, because that person, when you pass away, is going to control everything that you own and everything that's been properly funded to the trust because you retitled it, right? So you got to change the assets. You got to retitle them over to the trust. So the real estate, you're going to have to retitle it. So you're going to have to file a new deed at the county recorder. It's called a quitclaim deed, okay? You're gonna need to change bank and brokerage accounts, so any money market accounts that you got with Fidelity or any checking and savings account that you got with Chase or Bank of America. You're gonna need to put payment on death designations on the bank accounts, and the brokerage accounts, you're gonna change the beneficiary designations to be the trust. Membership interests in LLCs are closely held businesses. You're gonna assign those interests to the trust. You're gonna make sure that in the operating agreements, it allows for that, and upon your death, it doesn't transfer in a different way. However, if you are allowed to transfer your interest, then assign that over to the trust in any business that you own. You're gonna make sure that you pay all of your local county recording deeds and you are sure that you've done all of those things correctly and you've maintained your local requirements. You're also gonna maintain the trust. It's a living document. So once you do all of that, you've named everybody, you've changed all the titles, the assets, and everything else, you wanna make sure that if something else happens, you have to amend the trust. You have to make those changes. No one's gonna know, and you can't just say, I thought I wanted this person to do it, and they know they're gonna take over. You have to amend the documents in the trust. Once you've done all of those things, and you're confident in all the people you've chosen, and you've retitled all the assets, you have to have 2 separate witnesses that are disinterested witnesses, and find a notary, and then your trust will be complete. So I think you can get the gist of the fact that this is a pretty complicated thing with a lot of moving parts, which is why I think you should use a qualified and experienced estate planning attorney to create this. So who should use a trust? Like, who actually needs this? In my opinion, pretty much everybody, but more often than not, it's people that own a home, own a business, parents with minor children, parents of blended families most definitely need a trust. Let me tell you why. You remarried, you guys love each other, you both have your own children, and then you die. You want that person that you just married to be happy. So you want them to find someone else. Except when they find that other person, if you don't have a trust that's set up for a blended family, your children might accidentally get disinherited. They might not get anything because your new spouse found their own new spouse, and that new spouse has their own children. So those children and your original spouse's children are going to get taken care of. Your children might get left out in the cold. So definitely, if you have a new blended family, trust is for you. Anyone who wants privacy or asset control, trust is for you. No public filing of what you own like there is in a will. Anyone who wants to avoid court delays or fights, if your estate's under $20,000 in North Carolina and $25,000 in South Carolina, a simplified probate might work, but it's still going to be a public thing and it's still court controlled. A revocable living trust isn't about being rich. It's about being prepared for incapacity, for death, for what happens next. So if you're in North Carolina or South Carolina, you're a parent, homeowner, business owner, you more than likely need a trust, but you definitely need a plan. So click the link below, schedule a consultation, get our free estate planning checklist, or subscribe for more deep dives like this one.